Welcome back to the deep dive. We dig through the sources so you get the real story. Today, we're looking at something that keeps a lot of people up at night, a legal fight with the IRS, specifically a recent Supreme Court case, Commissioner of Internal Revenue versus ZUCH. Our mission here is to understand what this case means for your rights when the IRS wants to seize your property. What are the limits? And maybe more importantly, what happens if the government suddenly decides to drop the fight midway through your appeal?
Right. In this case, Zuck, it really drills down into jurisdiction. It's about where and when you actually get your day in court. Because let's face it, challenging the IRS is usually a pretty steep climb. This case draws a very clear line about when you can fight the tax before paying versus when you get pushed back into the old, much harder route. It's all about the tools you have.
Yeah.
So to really get what happened to Jennifer, Zuck, you need to understand the default rule first.
Right.
It's often called the pay first, sue later rule. It comes from something called the Anti-Injunction Act. Basically, you generally can't stop the IRS from collecting taxes up front. You have to pay the bill first, then you file a lawsuit to try and get a refund.
Which sounds incredibly difficult if you genuinely believe you don't owe the money and, well, maybe you don't have the money they're demanding. Like, how do you fight back if you have to pay first? But thankfully, there's a big exception, and it's exactly what ZUCH used. It's called the Collection Due Process Hearing, or CDP hearing. And the trigger for this, the crucial part, is when the IRS formally says it intends to levy. A levy means they're coming for your stuffed bank accounts, wages, maybe even planning to sell your property to cover the unpaid taxes. It's serious.
Absolutely. And because taking someone's property is such a drastic step, Congress built in this specific prepayment review, this CDP hearing. It happens with an appeals officer, someone in the IRS's Independent Office of Appeals. And the law says the taxpayer can raise any relevant issue. That includes challenging whether the tax is even owed, or the amount, and this is key, if you haven't had a prior chance to argue about it, like in tax court before. So this CDP hearing is potentially your best shot before they take anything. After the hearing, they also issues a formal determination. They either say, yes, the levy can proceed, or no, it can't. If they say yes, if they sustain the levy, the taxpayer has one more avenue. They can appeal that determination directly to the tax court.
Okay, so let's bring in the specifics of Jennifer ZUCH's situation. Her fight started way back around 2012 over her 2010 tax return. The IRS eventually said she owed about $28,000 more. But the real fight, the core issue, was about $50,000 in estimated tax payments. These were made jointly with her then husband. ZUCH said, hey, that $50,000 should cover my liability, and actually you owe me a refund of $22,000. The IRS disagreed. They put the whole $50,000 towards her ex-husband's separate tax debt. When they wouldn't budge on crediting her, they moved to levy her property for that $28,000.
So ZUCH did everything by the book. She requested the CDP hearing, argued her case, the appeals officer sided with the IRS, and then she appealed that determination to the tax court, just like the process allows. But here's where things get interesting. Procedurally interesting. While her case was slowly moving through the tax court, this took years. ZUCH filed her taxes for later years, 2013, 14, 15, 16, even 2019. And in those years, she had overpayments. She was due refunds. Now, instead of sending her those refunds, the IRS used another part of the tax code, Section 6402. It lets them essentially pay themselves back. They took her overpayments from those later years and applied them against the disputed 2010 debt, the very debt she was fighting in court. They just kept doing this until, poof, the 2010 liability showed zero on their books.
Wait, so the IRS basically used money they owed her from later years to wipe out the debt she was actively challenging in court?
That's exactly what happened. They offset the debt using her subsequent overpayments.
That's wow. Okay, so once that 2010 debt was zeroed out, what did the IRS do in court? They made their move. They went to the tax court and said, this case should be dismissed. It's moot now. The argument was pretty simple. The debt is zero, so there's no reason to levy her property anymore. No levy threat, no case for this court.
But ZUCH didn't want the case dismissed, and this is the crux of it all. She needed the court to rule on the original issue. Was the IRS wrong about that 2010 debt in the first place? Because if the court said, yes, the IRS was wrong, that debt wasn't valid, then the IRS would legally have to return all those later overpayments they'd kept. She wasn't just fighting the levy threat anymore, she was fighting to get her actual money back. The tax court, however, agreed with the IRS, dismissed the case. The Third Circuit Court of Appeals reversed that, and that's how it ended up at the Supreme Court.
Right. So the big question for the Supreme Court was, what exactly does the tax court get to review in these CDP appeals? Is it just the decision to levy, or can it rule on the underlying tax dispute itself, like the $50,000 payment issue?
And the Supreme Court majority came down pretty firmly on one side. They emphasized that the tax court has limited jurisdiction. It can only do what Congress specifically tells it to do. They look at the word determination in the statute. The majority said that refers only to the output of the CDP hearing, the simple yes-no decision. Can the levy proceed? ZUCH's argument about the $50,000 payment, that was just an input, according to the court. An issue raised during the hearing that informed the appeals officer's decision, but not the determination itself that the tax court reviews. They even pointed to the title of the law section, Notice and Opportunity for Hearing Before Levy. They said this shows Congress's focus was narrowly on stopping the collection action, not on settling all tax disputes forever.
Okay, so connecting that back to ZUCH. The moment the IRS used those offsets to make the levy unnecessary, the Supreme Court is saying there was no longer a determination for the tax court to review. The tax court's power in these cases is basically just to hit the brakes on a seizure. It can't, according to the majority, order refunds or make final rulings on the debt itself if there's no active collection threat.
That's the holding. The tax court dismissal was correct because once the levy threat disappeared, the court lost jurisdiction over that specific type of proceeding. It couldn't rule on the underlying tax liability in that context. So ZUCH's only path forward now, the court said, is the traditional one, a separate refund suit in district court, which apparently she had already filed just in case. Back to pay first, sue later, effectively, even though the payment was forced through offsets.
But not everyone agreed. Justice Gorsuch wrote a dissent, and it raises some pretty serious concerns, right? He argued the majority read the statute too narrowly. He thought the determination does include resolving the underlying tax liability, especially when that was the whole reason for the hearing. And here's the part that really jumps out the thing. The dissent warned this ruling basically gives the IRS a playbook, a roadmap for evading tax court review. Think about it. The IRS can start a levy, force the taxpayer into tax court, see which way the wind is blowing, and if it looks like they might lose on the substance of the debt,
they can just offset the debt using later payments, make the levy moot, and pull the plug on the tax court case.
Exactly. Avoiding a potentially unfavorable ruling on the core tax issue and making the taxpayer start all over again in a different, potentially more expensive court.
And the dissent highlighted a real practical problem. This creates a potential trap for the unwary. See, to file that separate refund suit in district court, ZUCH first needs to file an administrative refund claim with the IRS. And there are strict deadlines for that, usually just 2 years from when the tax was paid. Now imagine you're ZUCH. You're fighting in tax court for years under the CDP rules. You probably assume that process will resolve everything. You might have no idea you also needed to be filing separate protective refund claims for those offsets the IRS was applying along the way. By the time the IRS pulls the rug out and gets the tax court case dismissed, the 2-year clock for claiming refunds on some of those earlier offsets might have already run out. The dissent worried this could mean taxpayers lose out on getting all their money back simply because of this procedural maneuver.
So let's boil this down. What's the absolute bottom line for you listening to this? If the IRS comes after you with a levy notice, that CDP hearing is a crucial chance to fight the debt before paying. That right still exists. But, and this is the big but from ZUCH, if the IRS finds a way to stop the collection action, like by using later refunds to zero out the debt, your tax court fight under the CDP rules ends. Right then and there. You're forced back to square one, needing to file a regular refund claim and potentially sue in district court.
Precisely. The ruling confirms the IRS has this powerful procedural tool to essentially change the venue mid-fight. So the critical takeaway now is recognizing that risk. If the IRS stops the levy, that clock for filing administrative refund claims starts ticking or might have already been ticking. So here's something to think about. If you find yourself in a CDP fight, knowing the IRS might just drop the levy later, what else should you be doing simultaneously to protect your ability to get those refunds back down the road? Are there protective claims you need to file now just in case?
A very real and potentially costly procedural lesson from the highest court. Definitely something to keep in mind. Thanks for joining us for the deep dive. We'll catch you next time.